So if you're a federal employee, you need to know that your prenup might have some hidden traps. Seriously, these are things most lawyers and probably you would completely miss. And these mistakes, they could cost you hundreds of thousands of dollars from your retirement. Let's break down exactly what you need to know. Right, let's put ourselves in that situation. I'm a GS 14, I've been with the government for about 10 years, and I just got engaged. I know I need a prenup, to protect my retirement benefits. So I hire a lawyer, we sign the papers, and I figure I'm all set. But am I really? Is it really that simple? That is the perfect question to be asking right now. Because here's the thing. That standard issue prenup your lawyer probably drafted, there's a really good chance it's completely useless when it comes to protecting your federal benefits. And the reason is simple. Federal retirement plans just don't play by the same rules as the ones in the private sector. And this right here is the core of the problem. You see, most private retirement plans fall under a law called ERISA. It's the standard. But your federal plan, your first pension, is totally exempt. It's run by a completely different set of rules under Title V of the U.S. Code. And that one little difference, well, it changes absolutely everything. Yeah, and that legal difference leads us to the single biggest and most costly mistake we see people make. To actually protect your FERS pension, your legal documents have to use very specific language. I mean, they're like magic words, really. And most attorneys outside of federal law have never even heard of them. Exactly. So in the private world, the order to split a pension in a divorce is called a QDRO. You've probably heard of it. But for a federal pension, it's called a COAP, a court order acceptable for processing. If your lawyer puts the word QDRO in your federal prenup, the Office of Personnel Management, or OPM, is just going to reject it outright. The language has to be perfect. And look how picky they are. This shows you how critical every single word is. If your paperwork calls your pension an account, OPM says, okay, that just means the money you personally put in. It doesn't mean the much, much larger lifetime pension you've actually earned. One wrong word could literally cost you your entire retirement annuity. Hold on. So you're telling me if my lawyer just pulls out their standard prenup template, the part about my FERS pension is basically worthless? And if, down the road, we did get divorced, my pension would be completely up for grabs? That's exactly right. Without a valid prenup that uses the correct language, the court just steps in and divides the pension. And they usually use what's called a pro rata formula, just like in this example. Say you work for the government for 25 years total, and you are married for 15 of those years. Well, that means 60% of your pension is considered marital property. Your ex-spouse could then get half of that 60%. So if that part of the prenup fails because of one wrong word, your pension is divided by state law. And for a long-term federal employee, let's be clear, that one mistake could easily cost you hundreds of thousands of dollars over your lifetime. It's a huge, huge financial hit. Okay. So the pension is complicated. But my thrift savings plan, the TSP, that's basically just a 401k, right? That's got to be more straightforward to protect in a prenup. You would think so, but your TSP has its own special trap. Federal law actually gives your spouse a kind of veto power over your own money. The law requires your spouse to give written, notarized consent for most loans or in-service withdrawals you want to take from your own TSP. And get this, a prenup cannot override this federal rule. And hey, don't just take our word for it. This comes directly from official federal benefits guidance. It says, black and white, that a prenup does not count as an exceptional circumstance to get around the spousal consent rule. The government just doesn't care what your prenup says on this point. The bar to get an exception is unbelievably high. You basically need a court order that proves your spouse has either disappeared or abandoned you. As you can see, we signed a prenup is not on that list. So what this means is, during your marriage, you need your spouse's signature to access your own TSP funds. So think about what could happen. Your spouse could literally hold your TSP money hostage if you need a loan for a big home repair or some family emergency, and they just refuse to sign the consent form, you're stuck. Now, a good prenup can't eliminate the rule, but it can include specific language where your spouse agrees ahead of time to give that consent whenever you ask for it. Wow, okay, this is a lot to think about. So let's talk about what happens if one of us passes away. I'm assuming my prenup and my will can make sure all my stuff, especially my TSP, goes to my kids or whoever I want it to. That might be the most common and by far the most expensive misconception out there for federal employees. Thinking your will or your prenup controls who gets your federal benefits is just completely wrong. When it comes to your thrift savings plan, only one document on the entire planet matters: Form TSP3. It's the designation of beneficiary form. This simple piece of paper overrules everything else. It overrules your will, it overrules your trust, and yes, it overrules your prenup. See, the TSP has a very rigid order for who inherits the money. Number 1, it goes to whoever is named on your TSP3 form, period. If that form is blank or not filed, it automatically goes to your surviving spouse. It doesn't matter one bit what your will says, your spouse is the default winner. So the bottom line here is insane. If I get married and I just forget to update that one form, my entire TSP, which could be hundreds of thousands of dollars, would automatically go to my new spouse, even if my will and my prenup both say it should all go to my kids from my first marriage. That's the mistake? That is the mistake. And believe me, it happens all the time. Now let's shift gears and look ahead a little, because there's a huge tax law change coming in 2026, and it makes lining up your prenup with your estate plan even more important, especially for feds with a lot of assets. Okay, so a new law is permanently boosting the federal estate tax exemption. Starting in 2026, it's going to jump to $15 million per person. That means $30 million for a married couple. This is a massive increase from where everyone thought it was going to be. So why does this matter to you as a Fed? Well, think about it. The present value of your first pension can easily be over $1 million. Now add a large TSP balance and your other assets on top of that. Suddenly, your estate is playing in a whole different league. Your prenup has to work perfectly with your total estate plan to handle these huge assets and these new tax rules. Okay, that was a lot to take in. Let's just run through the biggest points again. 1. For my FERS pension, the magic word is COAP, not QDRO. 2. My prenup can't get me out of that spousal consent rule for my TSP. 3. Form TSP3 is king. That form and only that form decides who gets my TSP. And finally, I have to update all my beneficiary forms the second I get married. You can see these rules aren't obvious, and they are totally different from the private sector. It's why making sure your legal and financial plan is built specifically for a federal employee isn't just a good idea. It's absolutely essential. So I guess the question to leave you with is this. Now that you know all this, is your financial future really as secure as you thought it was an hour ago?